Mayor, next item, if I can give just a little bit of history on it. This is a proposed non-discrimination ordinance. It was back on the council table in July of 2020. Constituents, approached Councilor Garrett and others probably a year or so ago about requesting this non-discrimination ordinance. There are 10 cities in Georgia that have adopted non-discrimination ordinances, including Atlanta, Brookhaven, Clarkston, Chamblee, Decatur, Dunwoody, East Point, and Smyrna, most recently back in August. Augusta is also studying the same thing. They have different formats. Some of them send cases to Recorder's Court for enforcement. Some of them send complaints or cases to mediation, but they are a fairly common phenomenon now in Georgia cities. They are, becoming more, I guess, familiar to people in the last year or so, but it's on the table again for discussion. If councilors want to delay it, it can be studied. That's what they've done in Augusta. But we've been here 6 months ago, and we're back for further discussion, and we'll let Councilor Garrett have it or whoever wants to comment.
Councilor Garrett.
Thank you, Mr. Mayor. What I would like to do, if there's anyone here tonight who wants to speak to it, I am going to be making a motion to continue the first read to the first business meeting in May. So that would be on May the 11th, and then that would force a vote on this issue on May 25th, so that could get all the groups that have expressed concerns or support for this ordinance together. Even proponents of the ordinance have said that they want to have a little bit of time to get that together. So if there's anyone here tonight who cannot speak at that next meeting, please go ahead and voice your opinion tonight. But if you can attend the meeting on the 11th, that will be up for a first read if the rest of the council supports my continuing first read. Thank you.
All right, we have Councilor Woodson who is next, who wishes to make a comment.
We've got somebody in the audience also.
Hello, Mayor?
Yes, we can hear you.
Okay, I just wanted to second Garrett's motion to the delay. I'm in support of this, but we've had conversations with people in the community, and we agree to just delay this. But I am in support of it and love to hear what constituents have to say tonight.
Okay, well, there is a motion and a second to delay or continue on first reading until the first business meeting in May. And we'll hold that vote until, I guess, till after the individuals are heard.
That's fine. Ma'am, in the back there, if you want to be heard, come on up, please. I saw a hand in the back.
I think
Okay.
we've got some folks that are queued up, I think.
That's fine. If they're at the podium, come on up. We may need to take a mic to the back. I'm not sure.
Yeah, come on up. Just state your name and your address.
Hello, I'm DeMarcus Beckham. I am the Southern Field Organizer for Georgia Equality, one of the state's largest civil rights organizations. I'm out of Macon, Georgia. We're working on our ordinance as well, too, and I'm leading the charge there on that. But I want to say that I have had a helping hand in passing the last 4 ordinances out of the last 12 cities who have passed this in our state. I'm here to help clarify and offer some context to this piece of legislation that will further be discussed. I want to rush to disabuse you of any notion that this non-discrimination ordinance would tie the local government courts into any excessive litigation. I want to make absolutely clear that this ordinance does not offer any special rights or any specific to any specific groups, but only to bridge the gaps between federal and state laws that have addressed discrimination cases. When addressing many of the erroneous or fear-mongering tactics around discrimination ordinances, I first ask people, have they actually read the non-discrimination ordinance first? And many people say no. I believe that many individuals who this piece of legislation is focused around will be disabused or will not be protected. This ordinance is for people of color. This is for women, our residents who happen to have origins outside this nation. This piece of legislation is for our strong, brave men and women who serve our nation and our military. This piece of legislation is about people who are differently abled. Now, I want to talk about some of the most frequent questions that I'm asked about this piece of legislation. And I've got a chance to talk to many of the councilmen and women on this board about this. So I'll be going over a few of the points that I raised to them. This discrimination ordinance does not change how churches or private entities run their memberships. The only thing that it speaks to for these private entities is if they have a rental or commercial space, they cannot discriminate against anyone who wants to, for example, have a reception or any retirement party or wedding. These are protections that are already in the federal level. This non-discrimination ordinance will only extend it to people of color and people of the LGBT community. This non-discrimination ordinance does not affect school sports. Cities who have already passed this non-discrimination ordinance, no one has raised or used the non-discrimination ordinance to enforce any school sports rights. See here. And usually that matter is left up to the local school boards and not the city council. Just as today it is against the law for anyone to intentionally go into a public space or a bathroom to maim or harm anybody, that is already against the law, and after a non-discrimination ordinance is passed, it will still be against the law. No city who has passed a non-discrimination ordinance has experienced any cases of persons who have falsely identified themselves and to harm others. It is important to understand that this mischaracterization and demonizing of subsets of our community is a shameful, and it's also a century-old tactic for discrimination. And finally, small businesses do not have to change their business structures to accommodate. Now, what does this ordinance do and what can it offer your city? Georgia is one out of 3 states that doesn't have any workplace protections. You don't have to give a reason why you're firing a person here in this state. We're one out of 5 states that doesn't have any public accommodation laws that doesn't speak to people of color on the state level, as well as people of the LGBT community. A non-discrimination ordinance would help extend protections to combat any discrimination in housing rights. And understand that this ordinance is not about giving people special rights. 21 states have already passed it. Over 400 cities across the nation have already passed it. 12 cities, including Savannah, Statesboro, and Smyrna, who just passed theirs in the recent months. And also Asheville passed theirs about an hour ago. These laws are aimed to protect small businesses, our employees, and our patrons. Non-discrimination ordinances are a way to offer inexpensive, less time-consuming local remedies to address the patchwork of the federal statutes and only protect people and address is only to protect people and address the lack of state recourse. A non-discrimination ordinance would protect all of us if there is a valid case of discrimination. Most cities who have passed a non-discrimination ordinance have only experienced a handful of cases a year, little to limited stress on the local hearing officer, which is stated in the ordinance. Business owners and institutions, after the passage of NDOs, agree outward discrimination in any form is bad for business. So many small businesses already support measures similar to this. Discrimination ordinances also make cities more attractive to large business industries and event opportunities. The city of Savannah, who've already passed theirs, have referenced their passage of their NDO in their hospitality campaigns. Atlanta was able to secure their Super Bowl bid through their non-discrimination ordinance, and currently is referencing their non-discrimination ordinance for their bid for FIFA, the World Cup. In closing, this is a nonpartisan issue. Conservatives and liberals have agreed that this is a basic way to deter discrimination at a local level. I hope each of you counselors understand that there is no compromise in comprehensive. There's no compromise in being comprehensive. You don't have a duty to be like other cities across our state who've already passed these non-discrimination ordinances. You don't. But you do have a duty to each of your citizens. Now, again, I'm DeMarcus Beckham. Councilman Garrett has my information. I'm happy to walk you through what this piece of legislation has said, or it is stating. This is something that our city cannot wait on. Cities across our states, our great state, are looking to cities like Columbus. Y'all are leading the way. I hope y'all continue and consider this piece of legislation as something that is not for some, but for all. I do thank you.
Thank you, sir.
Okay. Anybody else want to comment there? Ma'am, come on up and give your name and address for the record.
My name is Brooke Martin, and I live at 2308 Gurley Drive. Thank you. I moved here in January 2018 because my husband was stationed at Fort Benning for his final years in the Army, and we've adopted Columbus as our home. We bought a house here. I work and volunteer here. We've made friends here. We shop in local stores and eat in local restaurants. I've made copious use of my library card in the last year. So I see Columbus, my home, considering adopting a non-discrimination ordinance, and I urge you wholeheartedly to do it. We have the opportunity to be leaders in doing the right thing and in protecting our most vulnerable citizens. So Columbus, let's be leaders. Thank you.
Thank you, ma'am.
All right, so tell us who you are and your address, please.
Hello, my name is Harry Underwood. I live at 8082 Veterans Parkway, apartment 4702, in District 6, and I am testifying in support of the Columbus Non-discrimination Ordinance. Here we go. Mayor Henderson, members of council, honorable members of council, I am testifying in support of this ordinance. As a resident of Georgia since 1993, when I was 6 years old, and a resident of the Columbus, Georgia since 2013, I am glad that we have reached this historic moment when we can discuss such an advancement in civil rights law for our diverse, complicated city. I first brought this idea of a non-discrimination ordinance before council back in 2014. It was one day during public agenda, and Mayor Tomlinson was in the center at the Citizen Service Center. And this was also my first time meeting several of you who are sitting on council today, including Councilman Barnes, Councilwoman Woodson, and many others. And I never stopped suggesting this idea that we should have a non-discrimination ordinance here in Columbus. I never stopped bringing it up to fellow residents. Never stopped longing for the day when this city could do our fellow residents a solid with such a law. But I also appreciate this opportunity for the people of this city to have our individual say on this ordinance and participate in the democratic process, as we should for any legislation being passed or considered by this council. First, I hope to clarify for those who are in attendance or watching, whether in support or in opposition, what this ordinance is and what it is not. This is not an LGBT rights ordinance exclusively, any more than it is an African American rights ordinance, any more than it is a rights ordinance for atheists. And I'm all three, by the way, even though I'm Black, gay, and atheist. This ordinance is a universal law which protects against discrimination in employment, housing, or public accommodations on the grounds of one's real or perceived race, color, religion, national origin, sex, sexual orientation, gender identity, age, disability, marital status, familial status, or veteran status. So yes, it protects straight people and cisgender people, just as it protects men, just as it protects people of Christian religion, just as it protects people of European descent, all from said discrimination, just as it would protect any and everyone else like myself and my friends who are speaking tonight in support. That said, I can confirm that this proposed ordinance does include the words sexual orientation and gender identity as protected classes under this law. Everyone here has a sexual orientation, and everyone here has a gender identity. In the past, and even in the present, fellow Americans and fellow Georgians have been fired from their jobs or denied housing or denied access to public accommodations on the grounds of perceived sexual orientation and gender identity, among other categories. What I ask is that the law of our city recognizes this reality and addresses it. One of the customary responses may be, oh, why fight a business which is discriminating against you on such grounds? Maybe you should go to another business which respects you and let the invisible hand of the free market work. But these businesses, renters, and vendors still have to operate under federal law, state law, and city law as to how they should treat employees and or customers. There are legal expectations as to their behavior, at least to their employees. If this sort of logic did not work out, if the logical extreme of this idea forced the passage of the Civil Rights Act of 1964 to protect against discrimination based on race, color, religion, sex, or national origin, then why should it apply to one's sexual orientation or gender identity? Also, one does not have to have a visible, persistent trait to qualify. One can experience discrimination not just on color, but also on aspects of oneself that one may not see, but may ask about. And sometimes discrimination can be targeted to one's mere lived experiences, such as how they practice their religion, or perhaps what country in which they were born, or perhaps one's veteran status, in which, or internal disability even. The parts of ourselves that we don't always see. How could these lived experiences negatively impact one's ability to perform as an employee, or live as a resident, or use public accommodations unless there is interference in the first place against that ability? If these traits are not as visible as skin color or sex and have nothing to do with one's abilities but still ought to be protected under law, then why should sexual orientation or gender identity not be considered traits worth protecting? And no one loses out when we hold all of us, all of each other, to these standards. No one loses out when the law stands on the side of all residents, be we straight or gay, cisgender or transgender, and for all of us who are in between. I hope that those who are currently opposed or skeptical to this ordinance can at least remember this. These traits and lived experiences do not have to be visible to everyone at all the time to be targeted with discrimination. That none of these should be grounds for discriminatory behavior in the first place from people with power. And that no one loses out when the law protects against discrimination on grounds which we all share. Someone may ask, okay, you may be right that not all shared traits are visible to the naked eye to be targeted for discrimination, but how many lesbian, gay, bisexual, or transgender people are there in Georgia who need this sort of protection, and why do we need this protection? Oops. Well, according to studies by Gallup and the Williams Institute, there are approximately 425,000 LGBT people aged 13 plus in Georgia as of 2020, with LGBT adults comprising 4.5% of Georgia's population. And we are uniquely poorly protected from discrimination under Georgia law. According to one tally of laws affecting LGBT persons, Georgia is the single least protective state when it comes to offering legal security to its LGBT residents. Georgia law, as it currently stands, does not prohibit government or business from discriminating based on a person's gender identity or sexual orientation. In other words, in Georgia, LGBT people may be fired from our jobs, denied housing, and refused service in all variety of public places based on who we are and who we love. In Georgia, 25% of LGBT workers reported having been discriminated against in employment, and 45% have reported experiencing discrimination and other harassments at the office in the preceding year. The experience of Georgia's LGBT workforce appears similar to national trends where roughly 1 in 5 LGBT persons report being treated unfairly by an employer in hiring, pay, or promotion. Wage inequity is also a serious concern, with a range of studies finding disparities ranging from 10% to 30% between heterosexual and homosexual workers. According to surveys conducted nationally and in Georgia, more than 3/4 of transgender persons have experienced harassment at work, and over 1/3 have lost a job due to their gender identity. And the only ways that we are currently allowed to seek restitution for such discriminatory employment practices is through federal court or the Equal Employment and Opportunity Commission, especially since the Supreme Court's ruling in Bostic versus Clayton County, Georgia this past June. But that ruling does not protect us from being denied public accommodations nor from being denied housing. And such an avenue is out of reach for most of us who cannot afford a lawyer to challenge such discrimination in such a court. Columbus, with this ordinance, can fill this gap for LGBT residents at the city level. This ordinance establishes an inexpensive local avenue by which residents can deliver complaints alleging discrimination by businesses, city government offices, public accommodations, and housing facilities, so that both sides can hash it out, make amends, and save money in the process. I believe that Columbus's residents, LGBT or otherwise, can sleep a little bit more soundly if this city can protect residents from discrimination based on factors which we cannot change and have no reason to change. Because having strong, comprehensive laws which protect against discrimination is one of the basic fundamental means by which Columbus can attract and retain talent to contribute to our economy. And I also believe that the ordinance thoroughly supports the freedom of speech, religion, and conscience, which are protected under the First Amendment to the U.S. Constitution. There is no conflict. Finally, someone may ask, well, what other jurisdictions have passed such a law as this? This must be some newfangled experimental idea from the bi-coastal elite. In 1972, the Michigan cities of Ann Arbor and East Lansing were the first 2 jurisdictions in this country to pass a non-discrimination ordinance which included sexual orientation. In 1983, Minnesota became the first jurisdiction to pass a non-discrimination law which included both sexual orientation and gender identity. Today, 23 states, most recently Virginia last year, the District of Columbia, and 400 plus cities and counties across this country have passed bans on anti-LGBT and other types of discrimination in employment, housing, and public accommodations. So when someone tells you that such protections are some bicoastal elite ideas from San Francisco or New York City, you can say that such laws came from neither the East Coast nor the West Coast, and not even from the Gulf Coast, but from the Great Lakes region close to the geographic heart of our country. Atlanta first passed their inclusive non-discrimination ordinance in 2000, nearly 21 years ago. And since then, at least 11 other Georgia cities, including Savannah, Sandy Springs, Clarkston, Decatur, Chamblee, Doraville, and Smyrna, have passed the same ordinances into their own city codes. In addition, the cities of Athens-Clarke, Macon-Bibb, and Augusta-Richmond have passed ordinances protecting their city workers from discrimination on the same grounds and are having, as my friend DeMarcus Beckham can attest, active and very comprehensive debates on passing ordinances like what you see before you tonight. And I hope that Columbus in 2021 can see fit to join this growing number of jurisdictions who are willing to protect all of our residents from discrimination in employment, public accommodations, and housing. Because these cities are working hard to attract and retain diverse talent who can enrich their community, their economy, and their culture, and so should we for ours. This is an opportunity to stop the brain drain to bigger cities and other states and make Columbus more of a powerhouse for West Georgia. I would like to thank Councilmembers Garrett, Barnes, and Tucker for taking point on this proposed ordinance, as well as City Attorney Fay and Assistant City Attorney Sheftall for their work on this bill, for their consideration of other cities' ordinances, and for hearing out residents like myself. And I ask Council to vote yes for the Columbus non-discrimination ordinance as written. Thank you so much.
Thank you.
All right. Anybody else over there? Okay.
Yeah.
Good evening.
Good evening.
My name is Gerald Mitchell, and I am the President and Chief Executive Officer of the Greater Columbus Chamber of Commerce. I have met or had the opportunity to speak with many of you, and I have been very grateful for those opportunities and look forward to the opportunity to engage all of you in the good work of our community going forward. I want to speak on this issue and first say that the Greater Columbus Chamber of Commerce does not condone or support discrimination of any type under any circumstances, full stop. We do appreciate the consideration for delaying this first read and being able to work collaboratively with this group and others to come to a meaningful solution as it regards to this or relates to this important issue. Again, I'll be brief, and I thank everybody for their support and consideration and look forward to continuing to work with each of you. Thank you.
Thank you, Gerald.
All right. If that's all the hands in the audience,
All right. I think
are there any comments around the table?
I don't see any. There is a motion and a second to continue first reading on the 11th.
And we will
May,
bring,
I need
we
to
will
make
bring it back at that time on first reading for
Right.
another public hearing. And if there are any meetings in the meantime that result in possible amendments, we'll discuss those at that time.
All right, we need to make note that on that day, on the 11th, our meeting will be held in the North Hall, just closer to the entrance and the front office. Just that one meeting, so we'll want to make sure that we publicize that and make sure council's aware that on the 11th we'll be at a different location. All right, there's a motion and a second to continue our first reading till the 11th. Any more discussion? All in favor say aye. Any opposed, no. All right, it is delayed. Councilor Davis?
Yeah, Mayor, I want to ask the city attorney in thinking about this, when the city has lawsuits or employment matters or discrimination cases, do we hire outside experts and outside attorneys to assist us in those matters?
We do. In employment cases, we have in the past on where the government employee has sued the government or the former employee for any type discrimination, retaliation, sexual harassment. We've had a combination our office and other outside attorneys work on cases. We've had a few of those go to trial. Most of them are, resolved short of a trial.
Have we had any of these lawyers that we use, the professionals, discrimination lawyers, take a look at this proposed statute?
Yes, we have. There are a couple of ladies in particular at the Page Scranton firm that do employment work that have looked at this.
Do we have access to their comments?
Well, I mean, we can discuss it in a confidential meeting if you want to. I mean,
Okay, I was just thinking along the lines and listening to what I was hearing tonight that it might help to have input from experts or professionals who practice this day in and day out to help us craft something. I mean, I'm sitting here saying I'm open-minded, but to be able to look at it and help and assist to try to pull something collaborative together to make it very positive in nature. I think that they would be the ones that
well, and if it would help, we can get a written opinion, be confidential to you, the council, and, discuss what's on the table here in this draft. If you'd like that, we can get that.
Sure. I'd like to see that. I think it would help in assisting to work through this matter, but I think everybody wants to make sure that, I don't want anybody, there's a lot of people watching the meeting tonight, and first of all, I don't want anybody to perceive that our city is a city that has the nature or the character of discrimination. We don't. We're just like anybody else. All the laws are afforded to each and every citizen across the board. Matter of fact, one of the things I like about the proposed ordinance is that 3/4 of it, or 2/3, basically mirrors the federal law that protects each and every citizen in the United States of America. So that's a good thing. I think the process might be an area where of the channel that to get some kind of a resolution, as it was stated, might be need to be explored to find a way that we can make sure that we do it in the right fashion, that everybody is equal and fair and that it's just and that everybody's represented from a due process standpoint. And I think it would be wise. I heard the chamber talk about working together and having some input. I appreciate the council members and their willingness to be open to that and to try to do something collectively that serves our whole community, because that's what really at the end of the day it's going to affect. It's going to affect each and every one. I know there's a lot of exemptions in this that needs to be noted, but it does serve and affect our whole community, and therefore the character of our community should have a voice and have an input into this statute.
All right, thanks, sir. Councilor
Okay.
Garrett.
I was just going to say, I appreciate Councilor Davis email me his concerns and another councilor email me concerns. All I ask is that since we really want to get this voted on before the end of May, because this has already been delayed for so long, please go ahead and email your concerns. Email whether you have some sort of position on it one way or the other, whether you have something that you want us to address, because we're going to do this as efficiently as we can, involve every stakeholder we can. And we do want to hear from everybody, but we do want to get this voted on before the end of the month, next month. So I just ask that you go ahead and email me your comments either way and copy the assistant city attorney, and we will incorporate all those and make sure you're involved in any discussions. Thank you.
Yeah, I would recommend some type of meeting from interested parties along with the counselors, and so that there can be a dialogue. That didn't happen when it was tabled before, and I think this is an opportunity to revisit it. And I think that it needs to happen pretty quick, because that the 11th is going to sneak up on us fairly soon. Councilor Tucker.
Do we need to add the chamber? Because one of the questions that they had was, wanting to make sure it's inclusive and that they have a voice as well. So do we need to include them as a party?
Thank you, ma'am. Councilor Garrett.
I'm hoping they'll help organize it because they know many of the stakeholders who have concerns.
I don't want to speak for Mr. Mitchell, but I bet he'll be reaching out to organize a meeting.
Yeah. Thank you.
All right.
All right. Thank you, Mr. Mitchell, and all the others that commented. We'll bring that back in 2 weeks and probably have some discussion before then.